Our next story is Free the Nipple Fort Collins versus the City of Fort Collins. This is a case dealing with whether or not women have the right to go topless in Fort Collins, Colorado, and by extension in the 10th Circuit Court of Appeals, which recently decided this case and which judgment just recently became final. The 10th Circuit Court of Appeals includes Utah, which of course is pretty interesting. So we're going to read this decision and we're going to see what the Court of Appeals had to say in terms of the constitutional right of women to go topless in Colorado and other states of the 10th Circuit. So let's read this and see what they had to say. The city of Fort Collins, Colorado enacted a public nudity ordinance that imposed no restrictions on male toplessness, but prohibits women from baring their breasts below the areola. In response, Free the Nipple, an unincorporated association, and two individuals sued the city in federal district court. They allege other things that the ordinance violates the Equal Protection Clause, and they asked for a preliminary injunction to halt enforcement of the ordinance. The district court agreed, enjoined the city, pending resolution of the case on the merits, from implementing the ordinance to the extent it prohibits women, but not men, from knowingly exposing their breasts in the public. The city then brought this interlocutory appeal to challenge the injunction. This appeal presents a narrow question. Did the district court reversibly err in issuing the preliminary injunction? We answer no. Exercising interlocutory judgment, we affirm the district court, and this judgment has since become final. So we're going to read what they said. No state shall deny to any person within its jurisdiction the equal protection of the law. The Equal Protection Clause, as the United States has interpreted it, directs that all persons similarly situated should be treated alike. At a minimum, it requires that any statutory classification be rationally related to a legitimate government purpose. But more stringent judicial scrutiny attaches to classifications based on certain suspect characteristics. These characteristics often seldom provide a sensible ground for differential treatment. Gender, for instance, frequently bears no relation to an ability to perform or contribute to society, and statutes that differentiate between men and women very likely reflect outmoded notions about relative capabilities. As a result, gender-based classifications call for a heightened standard of review, which is dubbed intermediate scrutiny because it lies between the extremes of rational basis and strict scrutiny. To survive intermediate scrutiny, a gender-based classification needs an exceedingly persuasive justification. The classification must serve an important governmental objective through means substantially related to achieving the objective. The city acknowledges that the female-only topless ban is gender-based classification and that to pass muster under equal protection, gender-based classifications must satisfy intermediate scrutiny. But instead of drawing the logical conclusion that female-only topless bans warrant intermediate scrutiny, the city interrupts the syllogism. It asserts that the fundamental requirement of any cognizable gender discrimination case is invidious discrimination, not simple classification on the basis of gender. Some of the court's early protection cases, such as 1979's Parham versus Hughes, did treat invidiousness as a threshold inquiry. Yet Parham, if never overruled, is outlined in light of court's more modern equal protection jurisprudence. Since then, the court has consistently recognized that statutes supposedly based on reasonable considerations may in fact relate to archaic and overbroad generalizations about gender or outdated misconceptions regarding the role of females in the home rather than the marketplace and world of ideas. Today, hardened scrutiny attends all gender-based classifications. Invidiousness still matters, but only in challenges to facially gender-neutral statutes that disproportionately and adversely impact one gender. Here, however, the city has enacted, and plans have challenged, a public nudity ordinance that prescribes one rule for women, requiring them to cover their breasts below the areola, and a different rule for men, allowing them to go topless as they please. The ordinance creates a gender classification on its face, taking invidiousness out of the equation. The success of the equal protection claim depends only on whether the ordinance survives intermediate scrutiny. The district court categorized as little more than speculation the city's claim that banning only flameless toplessness further important governmental objectives. Instead, the court found the ordinance discriminates against women based on generalized notion that, regardless of a woman's intent, the exposure of breasts in public, or even private home if viewable to the public, is necessarily a sexualized act. Thus, it perpetuates a stereotype ingrained in our society that female breasts are primary objects of sexual desire, whereas male breasts are not. As a result, the court concluded that plaintiffs demonstrated a strong likelihood that they will succeed at permanent injunction trial in establishing that the ordinance violates the Equal Protection Clause. The city challenges this conclusion on appeal. It argues that, in light of differences between male and female breasts, prohibiting female toplessness is substantially related to an important governmental objective, and a sizable majority of other courts have so found. We address the city's argument in two parts. Further, we discuss the focus of the city's defense, the physical differences between male and female breasts, and explain how such differences affect the constitutional analysis. Secondly, we determine whether the city's female-only toplessness ban survives constitutional scrutiny. In defending the constitutionality of the public nudity ordinance, the city emphasizes the physical, social, and sexual characteristics particular to the female breast. Citing a Wikipedia article, the city argues that the woman's breasts have social and sexual characteristics, although their primary function is breastfeeding. The article, as quoted by the city, describes female breasts, and especially nipples, as among the various human erogenous zones and claims it's common to press or massage them with hands during a sexual activity. The city claims that it figures prominently in women's perception of her body image and sexual attractiveness and have held sexual status in Western culture, arguably more fetishized than genitalia. But the sexualization of women's breasts is not solely a product of social norms, but also biology. Women suggest that the breasts have greater tactile sensitivity than men's. Though we're wary of Wikipedia's user-generated content, we agree with the district court that, of course, inherent physical districts exist between women and men's breasts, most obviously in the unique potential to nourish children. But this does not resolve the constitutional query. Physical differences between women and men the court has recognized are enduring. In some cases, the court has found such differences justify differential treatment, but not always. Any law premised on generalizations about the way women are or the way men are will fail constitutional scrutiny because it serves no important governmental objective. Generalizations, the court has explained, have constrained impact descriptive, though they may not be aware of many people still ordered in their lives. So as we inquire into gender-based classification objects, we must beware of stereotypes and their potential to perpetuate inequality. Even stereotypes frozen in legislation that have statistical support, we must reject measures that classify unnecessary and overbroad by gender when more accurate lines can be drawn. The city argues that the inherent sexual nature of the female breast as opposed to the male breast raise myriad concerns with permitting adult females to go topless in public without restriction. The city refers this to a preliminary injunction hearing in which three officials, the deputy city manager, the assistant chief of police, and the city's aquatics supervisor, discussed some of these concerns. The officials testified that female toplessness could disrupt the public order, lead to distracted driving, and endanger children. Citing these concerns, the city prohibits only female toplessness serves to protect children from public nudity, to maintain order, and to promote traffic safety, and we discuss each of these rationalizations in turns. The capacity to breastfeed is the first attribute the city claims sets the female breast apart. Yet the city's public nudity ordinance expressly exempts breastfeeding women from the toplessness ban, so even children who weren't exposed to their mother's breast as breastfeeding infants may still see a naked female breast if they pass by a woman breastfeeding in public, her right under the state law. The need to protect children arises instead from the city's fear of topless women parading in front of elementary schools or swimming topless in public pools, scenarios it described to the court at a preliminary injunction hearing. But the laws in neighboring cities of Boulder and Denver and many other jurisdictions allow for female toplessness, and the city presented no evidence of any harmful fallout. In fact, the district court found that the city provides no evidence that a law permitting public exposure of female breasts would have any significant negative impact on the public. In absolutely contrary proof, we, like the district court, found doubt that without female toplessness ban on the books, topless women would regularly walk through downtown Fort Collins, parade past elementary schools, or swim in public pools. We're left, as the district court was, to suspect the city's professed interest in protecting children derives not from any morphological differences between men and women's breasts, but from various stereotypes depicting women's breasts but not men's breasts as sex objects. But laws grounded in stereotypes about the way women serve are not important to governmental interests. To the contrary, legislatively reinforced stereotypes tend to create a self-fulfilling cycle of discrimination. Thus, the sex object stereotype, according to Dr. Roberts, serves a function of keeping women in their place. And the district court found perpetuating sex object stereotype leads to negative cognitive, behavioral, and emotional outcomes both for women and men. The court noted, for instance, that Dr. Roberts has testified about research linking sexual objectification of women to the view that at younger and younger ages, women are viewed as targets for sexual assault. So what's left? A female-only toplessness ban strikes us as unnecessary and overbroad means to maintain public order and promote traffic safety when more accurate and impartial lines can be drawn. For instance, the city could abate sidewalk confrontations by increasing the penalty for engaging in offensive conduct, and to reduce distracted driving, the city could target billboards designed to draw eyes from the road. But the city cannot impede women, and not men's, ability to go topless unless established a tight means, ends that survives intermediate scrutiny. We recognize that ours is a minority viewpoint. Most other courts, including a recently split Seventh Circuit panel, have rejected equal protection challenges to female-only topless bans. None of these decisions bind us, though, nor does the sheer volume outweigh our analysis. As we interpret the arc of the court's equal protection jurisprudence, we've reached our constitutionally sound result. At least since the case called Virginia, the arc bends towards requiring more, not less, judicial scrutiny when asserted physical differences are raised to justify gender-based discrimination, while casting doubt on public morality as a constitutional reason for gender-based qualifications. For these reasons, we believe the district court correctly analyzed the plaintiff's equal protection claim. The court did not abuse its discretion, including that because the plaintiffs made a strong showing of their likelihood of success on the merits, the first preliminary injunction favor weighed in their favor. So that is the end of the case as it relates to Free the Nipple Fort Collins versus the City of Fort Collins. And as I indicated in the 10th Circuit Court of Appeals, there's now a general requirement that women can go topless if men can go topless. But as the 10th Circuit noted, there is a split of authority on this. The 7th Circuit has gone the other way, and I believe the 8th Circuit has gone the other way, although the city of New York agrees with the 10th Circuit, and some other cities agree with the 10th Circuit as well. So there is a split of authority on this issue. Now, it's unclear that there's any issue for the U.S. Supreme Court here to resolve, because all these issues involve local bans or local regulations. So they're all interpreting local regulations, not a federal law or a constitutional issue. I suppose the U.S. Supreme Court could get involved to further clarify its equal protection grounds, but even though there is a split of circuits on this issue, they're all interpreting local ordinances, so it's not particularly immediately clear that the United States Supreme Court would grant cert on this issue, and if they did, what kind of judgments they would be giving, except maybe to clarify the equal protection analysis under the intermediate scrutiny analysis as it relates to this or other issues. But we'll see if there's any appetite. This case did not get appealed to the U.S. Supreme Court, which is one of the reasons it's now in effect. But with a circuit split, maybe one of them will someday petition for a writ of certiorari, and we'll see if the court wants to get involved, but that's not going to happen today. So that's all that there is about this case.